Welcome to Employee Termination Tips. My name is Christopher Neufeld, Neufeld Legal. And in this particular video, we're going to be discussing if you've lost your job, what's your next steps? What should you be looking to do? And we're going to talk to this from a lawyer's perspective and the legal aspects, because there's a lot more that goes into it. But in many respects, you really should be first addressing the legal aspect of it and getting the right lawyer involved so that you can let the lawyer who's got a clear head move forward on that aspect and thereby allow you to tackle those other aspects that you need to take care of, whether it's finding your next job, getting things together, getting your life organized, taking care of unemployment, taking care of your emotions, taking care of your family, figuring things out that are beyond the legal aspects of your recent job loss. So what do? Well, really, you need to be sitting down, collect all the information that you have, pull it together, and then contact an employment lawyer or contact a number of them and find the employment lawyer that you're comfortable with, who makes sense, is willing to work with yourself on terms that are agreeable to yourself, and provide you with the perspective that you need, that can assess your situation and provide you with the direction and framework that they're going to undertake to pursue your employment case, if there even is one. Because you might come across and you might get all the information over to the lawyer lawyer might analyze it and really feel that there is no case there to be made. So what do you do in that circumstance? Well, you can always go and contact another lawyer and get a second opinion as to where you stand. Because sometimes, in truth, there is nothing more that can be done. And you might go to 2-3 lawyers, and each of the lawyers might say the same thing. And a lot of that is in part due to where you are employed, what the laws of your particular jurisdiction are, and what your situation is. So what relates to a person who's working, let's say, in Nevada for the last 7 months and is an employee at will, as the term is defined, there might not be all that much that's available, especially if there's no employment contract that specifies anything further, and if there's no real case for underpayments, for harassment or discrimination, which is infrequent but sometimes exists. Whereas you might have another employee who, let's say, works in the province of Alberta, has been working for the last 5-10 years, and has a very substantive contract or substantive pay arrangement that requires them to operate away from home in the northern part of the province on a large project or projects. In that circumstance, the complexity, the jurisdiction, all those factors work into the situation and suggest that there's probably going to be something there. That's just speculation, but it is what it is. So what you want to be doing is you want to be contacting those lawyers, getting a sense of where it is, listening to what they're saying, following through on what they're asking of you. And one of the things that they should be asking of yourself is to collect a lot of information for them to properly review and assess your case. And some of that materials might not necessarily be available to you right now. So what you'll have to do is either you have to find ways to collect it, either from your former employer requesting it, or using other resources that you have available to yourself. Oftentimes, you still have access to your pay statements, access to your T4 statements, access to your pensions and benefit programs, access to your former contracts. And you want to collect all that information and advance it over to the lawyer so they can give you a proper assessment of it. And by doing that, at least you know stuff is being done. It's up to you really to collect the information, but then it's for the lawyer to go through it and make sense of it, because they're going to have a straight head to do it. That's what their job is. Yourself, once you get that over to them, you can focus on the other things. But get in contact, get the information out to them, and then once they have the information, they'll be able to work with you and discuss with you as to what is potentially available, what the challenges are, what the opportunities are, where they see the issues, how they're going to look to move it forward, what kind of arrangement they're going to look for. Are they going to look for a contingency arrangement, or is it a problematic one, and is it one where they're going to have to be charging you, and can you afford those charges? But if it's contingency because they identified stuff that they believe is worthwhile to pursue, then you look to pursue it. So once you've got their strategy in front of you, what they anticipate from the case, including all the challenges, because it's going to be challenging to take a case against your former employer, because these employers rarely, if ever, are wanting to concede that they have done something incorrectly, that they've underpaid yourself, and would rather have you just disappear off the face of the planet because they felt they've paid you more than enough as it is, and you're just coming back and trying to get money that you don't necessarily deserve. But that's what you're dealing with. And that's why, in many respects, you should be getting the lawyer involved, so the lawyer is focused on that, and you're not worried and in the middle of all this hassling about that only results in rejection coming back initially, challenges to what your position is, even though oftentimes those rejections and those arguments are baseless. But you don't want to be facing them by yourself in many respects. Instead, you want to have a lawyer there who can get the materials, deal with it, and explain to you what they're actually trying to do. Because oftentimes what they're presenting is inaccurate. And if it's just yourself and they start throwing accusatory statements out there saying that they're going to come after you for more money, then it's going to be very off-putting. But the fact of the matter is, if there's no basis for it and it just substantiates what your lawyer tells you, that is they're just afraid of the position you're taking and they have no veritable legal argument against it, well, then you deal with it as it should be by having the lawyer deal with it and be your blocker on these incoming legal challenges which have no substance to them. And that's how you need to be moving forward, so you can focus on other stuff, but get all the legal stuff properly in front of the lawyer early on, so that aspect at least is dealt with. So you can deal with all those other aspects, but get the lawyer involved early. Get them all the materials that they need. Understand what they're looking to do, and make sure you have perspective and you're comfortable with what they're presenting you with, so that they can take it on. They can take at least one element of stress off of you and pursue that angle while you go on and take care of other aspects, your mental, financial, emotional, physical well-being. Those things are critical, as well as that of your family. But you need to do that in conjunction with getting the legal stuff going and get it done fast and early, so that it is not one additional burden that you're carrying forward. And also it's something that you don't regret afterwards, because that's the other aspect that you got to be concerned about, is that not taking on the legal aspect, not even looking into it and just saying, I'll just take what I take. Well, unfortunately, what happens if one day you realize you got shortchanged significantly? Because I see too many cases where there's considerable shortchanging of employees with respect to termination pay, severance pay, or even former wages. And then, especially in a province like Alberta, where there's a over-reliance upon foreign payroll software, foreign payroll advice, and even foreign, when I'm talking foreign, I mean out of province, out of country, termination arrangements, severance arrangements. It's very problematic. And if it's later on, when you got a clear head, you come to a realization that you could have addressed this, but you shot yourself in the foot proverbially, it's problematic. Don't allow that to happen to yourself. Don't allow regrets afterwards to settle in when you can at least take the time early on to consult with at least one, if not two lawyers, and see if there's anything there. Because if there's something there, you really should see how to address it. And at least if you feel that it's not worth your time, at least you can feel confident that at least you looked into it and now you can move forward. And that's how you should be, in our estimation, proceeding with this situation when you've lost your job and you're trying to figure out what steps do you need to do, with one of them being the legal step, which we sought to address in this particular video. Thank you.